Welcome to Aspirant Study Circle. Despite the basic structure of the Indian Constitution being a much required judicial innovation, it is also looked at as being too vague. So the reason we are discussing about the basic structure is because we know that the basic structure was an outcome of the Kesavananda Bharathi case in 1973. So from 1973 to 2023, it will be 50 years. So you can very well expect a question not just on basic structure, but also the fundamentals behind the basic structure. That is the amendability of fundamental rights. So you can expect a question even on the amendability with respect to prelims. And also I expect there to be a question in mains this year or the next year. So now this question, let us break down this question. So much required judicial innovation. So this will be the first part. That means you are expected to write the necessity of having such a basic structure, and at the same time it is also being criticized for not being very clear. So that is, it is being too vague. So we need to balance both of these narratives and then give a beautiful conclusion in the last. Before that, let's just have a quick review of what took place before the Kesavananda Bharathi case and a few other judgments. Now we all know that in 1951, during Shankari Prasad case, the amendability of fundamental rights was brought into question. And at the same time, the questions of Article 13 and Article 368 were highlighted. Now, in Shankari Prasad case, the court decided that the fundamental rights can be abridged, they can be amended. And under Article 13, the constitutional amendment law will not fall into the category of law in Article 13 Clause 2. So this would be in 13 Clause 2. So under 13 Clause 2, any law that is in contravention of the fundamental rights will be deemed as void. But the constitutional amendment law does not fit into the law under the definition of Article 13 Clause 2. So now similarly, the issue of an amendability of fundamental rights was taken up in Golaknath case. So in Golaknath case, the Supreme Court reversed its decision, saying that the fundamental rights are immutable, sacrosanct, and they cannot be touched, they cannot be abridged. So in light of this development, the government had come up with a 24th Constitutional Amendment Act, where it said that it amended the Article 13 and 368 to such an extent that it could take away the fundamental rights. So, and next comes the Kesavananda Bharathi case, where in Kesavananda Bharathi case, it had reversed the Golaknath judgment, that is, and it had upheld the validity of 24th Constitutional Amendment, saying that yes, indeed, you can amend the fundamental rights. However, so these are the 3 points, 3 highlights that you need to remember, because see, as we've discussed, overruled the Golaknath judgment and also the validity of 24th Constitutional Amendment. And then at the same time, there comes an exception. That is the exception in the form of basic structure. That means the legislative process can abridge the fundamental rights. However, there is a caveat or an exception in the form of basic structure. So, and we need to also understand that the Supreme Court had invalidated, this is with respect to election disputes, you don't have to go in depth. So, and also in the 42nd Constitutional Amendment Act, the limitation, see, now this is very interesting because this had become a part of the basic structure later on. So, no limitation of the constituent powers of the Parliament according to 42nd Constitutional Amendment Act in 1976. That means the Parliament can do whatever it wishes to, even if it encroaches upon the basic structure. So, next important judgment comes with respect to this would be the Minerval Mills case. Now, no limitation on the constituent powers. However, the Supreme Court had made it very clear that judicial review is an integral part of the basic structure. So, the limitation does not, no limitation is the word that the Supreme Court was against. And that is the reason why it gave birth to judicial review as being a part of the basic structure. So this is a brief overview of the genesis of Kesavananda Bharathi case and the basic structure. Now, going to the question. Now, the question had clearly two parts. So, first we need to account for the judicial innovation. So, now we need to take up different cases to understand how judicial innovation had in fact helped in strengthening our political democracy. For example, in Kesavananda Bharathi case. So, in Kesavananda Bharathi case, you need to give example of supremacy of the constitution, supremacy of the constitution, right? Now, similarly in Minerva Mills case, as we had discussed earlier, so the limitation that was put in the 42nd Constitutional Amendment Act, that there will be no limitation on the constituent powers, that was not encouraged by the Supreme Court, due to which we have seen the rise of judicial review. So, judicial review will be an example under Minerva Mills case. Now, in Quixote Holohan case, now it's also known as the anti-defection law, the case with regards to anti-defection law. So, the fundamental foundational value that emerged out of such a case was free and fair elections. So, free and fair elections. So, now similarly, please do go through the S.R. Bommai judgment in detail, because it was indeed a landmark judgment, and we see to observe that the fundamentals of secularism, federalism were talked about and were considered were considered an integral part of the basic structure in S.R. Bommai case. So, similarly, we have different cases. In fact, you can quote different important cases as per your liking. So, similarly, in I.R. Coelho case, rule of law. In fact, rule of law, separation of powers was actually given due importance in the form of they being a part of the basic structure. So, rule of law and separation of powers. So, when you mention that, when you want to highlight the part of the question which is the judicial innovation, you need to mention at least few of these along with the examples of the basic structure. So, now let us come to the next part, which is it is indeed criticized for being too vague and not clear. So, what is the implication of such things? So, we have discussed, I think we all understand by the term separation of powers, which means that the legislature, the executive and the judiciary need to operate in such a way that they do not encroach into the operating spheres of the other. So, when you give such a such a power like judicial review, that means can Supreme Court or can the court intervene in any case possible? Of course, Supreme Court is highly reputed, and when it comes to give a judgment, when it comes to give a verdict, it is very considerable, it is very considerate towards the socio-economic political scenario of the nation. Nevertheless, it can be seen that because of separation of powers, the dilutions of separation of powers, there could be judicial supremacy. So, you can mention separation issue with respect to separation of powers, and thereby it could lead to judicial supremacy. Now, another thing is case to case basis. What do I mean by case to case basis? That means we do not know what exactly constitutes the basic structure. That means with the cases coming in, the Supreme Court organically would try to maintain or would try to give a list of those values, foundational values that would make up the basic structure. So, it is more or less giving more power to the judiciary. So, over here we can in fact give an example of NJAC. So, we know that during the in fact, do read about the judge's case, first judge's case, second judge case, and we also read a little bit about the collegium. So, NJAC was termed as unconstitutional. So, that means because NJAC was said that it would reduce the independence of the judiciary, and hence it is very important to know that on a case to case basis, the judiciary would determine what would come under the basic structure or not. So, that's an issue. Next thing is extra constitutional, and see, all of these points are pretty much linked. So, you need to have an idea as to how to present these points in a constructive way, right? Because we are talking about the judiciary of our nation. right? So extra constitutional meaning. Now, as we've discussed earlier, separation of powers. Now, the constitution does not mention anything with respect to the basic structure per se, but of course, and also see the judgment that was given in the 1973 Kesavananda Bharathi case, that was given with a majority of 7:6. That means the dissenting judges were 6 in number and the ones that accepted were 7. So this again becomes a major area of criticism, because now 6, the only difference is 1, and it is such a landmark judgment. So this example can again be mentioned, right? And of course, we've discussed about the fact that there is no clear-cut list. So all of these issues broadly represent the criticism of the basic structure. Now, once you have highlighted the importance of basic structure and then you delve into the constructive criticism of the basic structure, then we need to come up with a good conclusion. So, see, we do agree that the basic structure is vague, but at the same time it has helped in bringing about so many values that you and I enjoy even today. For example, our democracy, life to liberty, right? Even life to liberty was considered as a part of the basic structure. So such things strengthen the political democracy, and at the same time, we've even discussed that the basic structure intends to put a limit to curb the arbitrary actions of the legislative and executive. So I hope this was useful in a question and answer format. So we've understood all the parts, why it is a judicial innovation and why it is too vague, and we have examined the reasons as well. My name is Prashant. Thank you for watching, and if you do have any comments, any suggestions, please do comment in the comment section. Thank you.